This is Liberty Law Talk, part of Liberty Fund's online library of law and liberty. Your host is Liberty Fund Fellow Richard Reinsch. Our web address is libertylawsite.org, where you can subscribe, comment, find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org. Today we're talking with John Lawrence Hill about his new book, After the Natural Law. John Lawrence Hill is a professor at the Robert H. McKinney School of Law at Indiana University, Indianapolis, where he teaches constitutional law, torts, civil procedure, and legal philosophy. Professor Hill also holds a PhD in philosophy and a law degree from Georgetown University. John, welcome to the program.
Thanks for having me.
So, John, the title of your book, After the Natural Law, How the Classical Worldview Supports Our Modern Moral and Political Values. There's one of the more famous passages of American constitutional law was in the Supreme Court case, Planned Parenthood versus Casey, which upheld the constitutional right to an abortion, but sort of regrounded the right not as a privacy right, but as an affirmative pro-liberty right. In that opinion, there's a passage famously attributed to Justice Kennedy called the Mystery Passage, in which he said, at the heart of liberty is the right of each person, if I'm getting this correct, the right of each person to define life as they see it, to define the conception of life as they see it. And it's commonly seen as a, really an unbound passage. When you read it, you're like,
right.
Most people kind of have this reaction of this is just sort of postmodern insanity, and yet it really does seem to, in many ways, speak to the way we think about liberty in America now. When you read that passage, what philosophical system is Justice Kennedy appealing to? Because I think he would say he's appealing to a kind of a modern natural right position.
Yes. Justice Kennedy actually gave an interview with New York magazine, I think it was, about 15 years ago, maybe 20 years ago or more, where he talked about John Stuart Mill and said that if there was one particular thinker who had shaped his own thinking philosophically, it would be Mill. And when I hear that passage, I think it's pure John Stuart Mill. It's Mill's whole idea On Liberty. In fact, in Chapter 3 of On Liberty, famous chapter, Individuality is an Element of Well-Being, and Mill talks about how the essence of freedom really is a kind of self-definition, a defining of the self and actualizing. He doesn't quite use the word self-actualization, that came later, but he talks about, I call the concept self-individuation, that one sort of decides what one's goal is in life, what one's meaning is in life, and then the essence of freedom is to leave people alone, to let them shape their own vision of the good life. And I think that Kennedy was channeling John Stuart Mill at that moment.
So that sparks to mind a lot of questions. In your book, you're defending classical natural law, and many would say in America what we have is we're a modern natural rights republic. Maybe we don't necessarily need to go as far as Justice Kennedy does in that particular opinion, and it may not be the case that John Stuart Mill is the way we should think about freedom in America. But that does spark to mind, I think, a question of why is, say, a natural rights conception of freedom and responsibility not enough for us? Because I take it you would say there are problems there. And there are deficiencies there. It can make complete sense of the free human person. So I'm curious to get your thoughts on that.
Well, a couple of things. I mean, first of all, the book itself is written from, I suppose you'd say, a classical natural law standpoint in a broad sense. What it really does is Part 1 traces the development of the classical natural law model and Thomas Aquinas' thought in particular, but it ties together not just natural law but other metaphysical considerations. How do we think about freedom of the will? Is there such a thing? How do we think about the soul? How do we think, or is there such a thing? So it tries to tie together all of these ideas. In Part 2 then sort of takes us through Hobbes, Locke, Descartes, through Mill and other thinkers up to the contemporary period. And so Mill himself was, as you know, profoundly influenced by Romanticism, and his thought is really this sort of I think of it as kind of an unstable emulsion between his father's utilitarianism and the romanticism of his lover and later wife, Harriet Taylor. She sort of, I mean, if you remember the story, Mill had a nervous breakdown, and reading the romantic poets sort of brought him out of that. And so at the heart of the romantic idea is this sort of this notion that there's an authentic self. We have to sort of uncover it, and in Mill's notion, as he develops it in On Liberty, part of freedom from government, part of what would later be called the right to privacy, is really giving people a kind of a insulation to be able to become who they really are. And so it's a beautiful notion in a sense. It's an ennobling notion, but untethered from any objective conception of human nature. I think perhaps it's potentially unwieldy, dangerous. It can lead in any direction a person particularly wants. And so I think that where I part ways. I mean, I am very strong defender of liberty as well. I think what we need to do is to return to or to find some modus vivendi or some place where modern conceptions of freedom, liberty, and rights are still tethered to some notion of an objective order, an objective moral order. And that it isn't simple. I mean, Mill, and from Mill onward, liberty gets relativized, and we wind up with people having a right to do wrong and lots of other very modern notions, which I think are ultimately destructive of liberty.
So when you think about natural law, I mean, and that's sort of an interesting question too, and you deal with this in the book. What is the natural law? And there's a dozen different conceptions of what that is. You say but we have to have a metaphysics and an anthropology to understand natural law. But the sort of conventional view is that's a part of pre-modern scientific thinking, and we sort of dispensed with that with this advance in knowledge that came through the scientific revolution, and formal and final cause are just wrong ways to think about in general, the external world and investigating nature. We don't need it. And we really don't need it with liberal regimes, which we want to allow people to pursue their choices, their options, their predilections, et cetera, as widely as possible, as long as they don't, use force and fraud and injure other people. But with the natural law conception you're writing about, there's a lot we have to be in agreement on, it seems. And is that itself just incredibly problematic given the type of regimes we live in now?
I'm glad you mentioned final causes, which is really at the heart of the sort of the classic natural law, the idea of teleology, and what the book does in chapter 5 of the book in particular is looks at these very early modern thinkers like Francis Bacon and Descartes and others. And what I found, and I was fascinated by this, is they were in Locke in his own way. In fact, even Occam in his own way a few hundred years earlier. I mean, what I found is that Bacon and Descartes and these earlier modern thinkers did not dispense with final causes. They continued to believe. In fact, Bacon says all knowledge is knowledge of Aristotle's four causes: efficient, material, final, and formal. To know what a thing is, we need to know all four causes. But we have to speculate about the final causes. They're not something that we can know empirically and through science. And so Bacon says, in essence, we have to bracket those causes. Let science proceed by looking at material and efficient causes, but let the final causes, leave that to the philosophers. And Descartes says the same thing. He says God could not take us into his counsel, or we could not believe that God would have taken us into his counsel in knowing what the ultimate goal of human civilization is and such. So he too says, of course I believe in these things. They exist. They're essential to what we need to know to live a meaningful life. But on a scientific, empirical level, let's stick with the material and the efficient causes. So these early thinkers hold on to all of that. but bracket the final causes. And it's only with thinkers in the later 17th and early 18th century that you begin to see this attitude of, well, we can't really know about it empirically. Why don't we forget about it altogether? And it sort of takes us down the road that we see by late 18th century and certainly today, where people don't even understand what a final cause is. So I guess I just wanted to say, I think even for these modern thinkers, there was this attempt to hold on to their Christianity and somehow merge it with or make it consistent with their materialism, or their, in Descartes' case, the physical side of nature works mechanistically, but there's this inner side, and it's fascinating to see how that breaks down. John Locke's another good example, and I kind of trace that in that particular chapter.
We think about Bacon or Galileo. They would argue, though, they're owning nature. They're making nature do work that it hasn't heretofore, that man has not been able to do. And it's going to be used famously to improve man's estate, his lot in life. There's clearly this idea of man as the master of nature, knowledge as power, and it seems to me that is also sort of the byproduct of the bracketing of final cause, as you say, but starts to lead to a very different conception of how human beings use their freedom. It is almost. Sometimes when you read passages in Galileo or Bacon, it's almost, you do sort of get these whiffs of will to power.
Yes.
And how they are using science, or how they think it should be used.
And I think I think that period was an incredibly heady time, particularly for people who were immersed in thought. Descartes said very famously on this night of his sort of conversion to philosophy, that the night that some people say is the very night modern philosophy was born. November of 1619, and he says, I was struck by the disunity of all the sciences, that we had built up this sort of Aristotelian Thomistic worldview, and in the last several years, Galileo in particular, we see it coming undone. And I think there is this sense of ambivalence that many of these thinkers had. Yes, the whiff of the will to power, but at the same time a sense that there is an order, and that we are, in a sense, exploring God's mind. In fact, even Newton talked about his mechanics in terms of understanding the mind of God. So there was still this sense that there was something objective outside of us that we were coming to understand, rather than sort of willy-nilly creating something of our own.
Question for you: when I'm reading as I was reading your book, a book that's canonical to the American conservative movement came to mind. That was published, if I'm not mistaken, I think in 1948 or 49. Richard Weaver's Ideas Have Consequences. In that book, he argues the beginning of the decline of Western civilization was with a monk, William of Ockham, and his nominalist philosophy, in that we have no universals, we only have particular things, particular names that we give things, and to the extent we think we have universals, it's just a convention of naming. We don't have access to reality in that capacity, in that sense. And for Weaver, this resulted in a long train of consequences for society, for our politics. Is your book, are you kind of agreeing here with Weaver that there's sort of, in the Western mind, whatever deficiencies there were, say, in the high Middle Ages, from that point on, once William of Ockham begins writing, and then Descartes, and then Locke and Hobbes, and the way they sort of reconceive of human freedom and responsibility, that there's just sort of this decline, and it's ultimately traceable to this dismissal of the metaphysics and anthropology presupposed by Aristotelian scholastic framework?
I'm in broad agreement with his point there. Yeah, in fact, that introduction, I think he lays out, Weaver lays out in about 15 or 17 pages, this decline beginning with Ockham into the present, and it's really it's a brilliant introduction to the book. Yes, I think the idea is that Occam, of course, was the father of, we say he's the father of nominalism, the father that there are no essences, there are no, he didn't say there were no formal or final ends. He continued to believe in them. In fact, he continued to say he believed in a broadly teleological conception of the world. He was certainly not a mechanist the way Descartes was 300 years later, but he begins to, he sort of lays the axe at the root of the idea of essences and forms, and even the title of Weaver's book, Ideas Have Consequences. He meant that, of course, in the double sense, not only that our ideas in our heads, but Platonic ideas. And when we lose those, we lose, ultimately what we lose are any ability to speak meaningfully about the very laws of nature that later scientists would assume must be true. So to answer the question, I'm broadly in agreement. I think we need to rethink the idea of essences. I mean, I have particular difficulties with the way some of the classical thinkers thought about essences, and but I think that even our conception of the way knowledge occurs, sort of the modern materialistic or mechanistic idea, is problematic. It's hard to know that my idea of a certain thing, which is in quote unquote in my head, is the same idea you have in your head, without there being some form. And so and one last point, I guess I'm sort of riffing here, but I mean, it's Bertrand Russell, who is himself, an atheist and very familiar and attuned with the modern mechanistic or materialistic idea of the world, thought we need these ideas of essences or universals in some sense, that science cannot do without them. So you have some disagreement even among those who might otherwise be very modern or postmodern in their worldview, who think we've lost something here after Occam.
Yeah. Now you have sort of this, and I was talking about this. So I guess we're on this great hits parade of Western thinkers here, and
right.
Freedom and natural law. Two thinkers. One seen as sort of the philosopher of American constitutionalism, or at least broadly American lowercase constitutional thought, John Locke, and also Thomas Hobbes. So I'll ask you a big question. How do you see Locke in this?
Locke is just an incredibly fascinating guy, and I went back and really dug into his philosophy, his thought in writing this book. And when you look at commentators, they have one of two opposite views about Locke. He's either the last pre-modern thinker, still believed in this natural law, natural rights idea, at least in some conception. And then, of course, the other view, which is he's the father of liberalism and the father of modern empiricism. And the truth is, he was both. And when you read his second treatise of government, which is obviously a natural rights philosophy, and then you read the book that is supposed to be his greatest secular contribution, his essay concerning human understanding, he wrote both of those books at the same time in the 1680s while he was in Holland. And he was going back and forth, and you see these marvelous tensions and contradictions. And I just think he was an incredibly conflicted guy in a deep sense. One of the most interesting discussions is in his essay. He talks about freedom, meaning freedom in the internal sense, freedom of the will. What is it? And over the course of some 50 pages, he's tempted by Hobbes's position, which is deterministic, but no, that can't be consistent with Christianity and with the idea of the last judgment. People have to be punished, he says, in the end for things that they could have chosen otherwise to do. He tries various sort of modern tropes and responses to sort of the problem of freedom and determinism, and sort of goes from one to the other, and then kind of in the end comes back to a basic libertarian, metaphysical libertarian view. There has to be freedom of the will. And he wrote a letter to his friend William Molyneux, who's the guy who came up with that famous Molyneux's problem, which people have been debating about ever since, or at least debated about for a while. Until Molyneux was the guy who wrote to him and said, if a blind person who had become familiar with the feeling of roundness and the feeling of triangularity and the feeling of squareness, if suddenly their vision were cured and they could look at these things, would they be able to tell without touching them, this object is the round one? I know from my feeling. Well, is there, in other words, some innate connection between the feeling of sphericality and the sight of it? And do you think that's possible? And Locke very wisely said, no, I don't think the person would be able to know. I don't think there's an innate connection. And I'm kind of going off here, but Locke and Molyneux, and as it turned out, Locke was right. When a person was about 100 years later cured of sightlessness, they did the experiment and found that, in fact, a person who had never seen roundness could not pick it out based on what they had felt. Anyway, Locke and Molyneux had this great correspondence, and Locke confesses to Molyneux, if it be possible for God to make a free act, then so he can do it, but I see not the way of it. I think in the end, Locke just sort of he throws up his hands and acknowledges there is something about the mystery of human freedom in the sense of freedom of the will, that we just can't get our hands on. And in that question, I think, is at the heart of so many of the problems of modern liberalism, because freedom is both internal, freedom. I mean, our political liberty in some sense must be predicated on the idea that we have internal freedom of the will. And if that goes, I think it's very difficult to sort of hold on to external political and social liberty.
Yeah, a big movement here in Locke also you discuss, which is moral voluntarism, which is also connected to theological voluntarism. And this also going back to Occam is also working. Talk about that, and because that seems to me also crucial in thinking about Locke as well, and the ways in which that position, that very willful position, begins to actually undermine and work against freedom.
Yeah. Well, ultimately, is a Protestant. I mean, Locke, of course, was skeptical for lots of different reasons about the classical natural law. He certainly was skeptical for political reasons about appeals to innate ideas or to authority grounded on sort of essences and such. He's skeptical of all those things. But he begins to think of the natural of natural law, to the extent his rights are grounded on it, in a very different way than what Aquinas thought. I mean, for Aquinas, natural law was in us. We respond in a certain way naturally. Our reason is a function of the natural law. It's our participation in the natural law.
Participation, yeah.
And for Locke, natural law becomes an external dictate of God. Here is God's will. He's laid down a certain rule, and it's for us to follow it. But it becomes externalized, and it's a function not of reason anymore, but as you point out, of will. Yes, so much follows from that in modern jurisprudence and philosophy. It's really the root even of modern legal positivism, the idea that law is a function of, ultimately, of political facts.
The command of the sovereign.
Yeah.
Command of the. So a question that also comes to mind here while we're just sort of wildly speculating. No, we're not wildly speculating, but talking about the grand
spinning our wheels.
Western history. Yeah. So when Locke writes about this, what is freedom then for Locke? Because many would argue, and I think with obviously a lot of credibility, I mean the type of political order he's putting down in the second treatise does allow for remarkable economic, political, civil freedom, and it redounds to the benefit of mankind. And you can see sort of in this period, we have economic free. So you think about the famous hockey stick of economic growth within the West, and it's right about the 18th century, and then it just takes off. It's
Right.
incredible, and then you start to have then the political freedom comes along, and we see that, and so you do see the growth of liberty and its important dimensions here take off, while at the same time John Lawrence Hill thinks we're eroding the conditions of natural law, and therefore the conditions of correctly understanding human freedom and responsibility. I mean, there's what gives? Aren't the moderns actually getting something right here, which is the person, the individual, is finally being respected in his conscience, even if even if he uses that, or we can't actually understand all the ways in which we should act. It's better just to let people make up their own minds.
Well, I mean, in some broad ways, I think it is better. But I think we need to look at history as an arc and keep in mind that sometimes anything, what was it, Hegel said, anything taken to an extreme negates itself in the long run. So you have this period where these modern classical liberal ideas, but ideas still grounded on a conception of natural law, and obviously held by people who still, for the most part, retain a sense of a theological background. There is a God. There is, in some sense, a natural law. There is an objective right and wrong. And the problem is that as these ideas burn away in the 19th and 20th century, there's not a lot left in which to ground that freedom. And what I think we see now is a kind of relativistic egalitarianism developing, where sure, everybody has a right to think and believe what they believe, unless you happen to hold, for example, perhaps more traditional religious ideas that may conflict with the reigning secular or progressive orthodoxy. And Christian bakers being thrown out of their businesses for believing what they believe. This too is a part of what we get with the movement of this idea into postmodernity. This idea that anyone can believe what they want. I mean, it isn't as ecumenical as we might hope.
Do you think? One view is there's always an orthodoxy. And one is either being imposed or it is imposed, and we're never going to be long without some sort of overarching conception of how we're going to live together politically, and that sort of gets enforced down socially. In this conception, though, that we're talking about, it's interesting to think about the American Legal Academy here. I suppose, I tend to think of law as sort of downwind of philosophy. Many people would say politics is downwind of culture. I think they're both mutually enforcing or reinforcing the other. But the American Legal Academy, as you know, famously does not think much of natural law. And although as we were discussing earlier, it does seem like Justice Kennedy can spin any number of conceptions out of the word liberty and the Due Process Clause in the 14th Amendment, which is interesting in its own right. But with the American Legal Academy, I suppose that they are, and I think this goes back to what we were discussing earlier, there is sort of a positivism at the heart of American legal thinking in the 20th century in particular. And I think it's famously explained in one sense as being in the famous opinion Erie Railroad, where an idea of a national common law is rejected in that opinion. And one of the reasons given is that was predicated on an older understanding that we discovered law.
There's no brooding omnipresence.
There's no brooding omnipresence in the sky. So, a particular explanation of that. But it is the case. It seems to me that it's hard to begin to make these arguments in the American legal system at this point, given kind of where we are.
I think that it's always in moments when things are secure or relatively secure, and we're able to kind of get along with our more confined, positivistic, relativistic notions. We get along just fine. It's always in moments when we're sort of pushed to the brink, when we have to appeal to these deeper sources. So I mean, the Nuremberg trials are a great example of that. I mean, you had, as you very nicely pointed out, in the first half of the 20th century, I mean, modern legal opinion, Holmes, Brandeis, all of the greats just made fun of natural law. Holmes, by the way, has a very funny law review article called Natural Law, where he trashes natural law in the most humorous of terms. I mean, he's clearly having fun with it. And yet, by the time World War II ended, Justice Jackson is sent over and has to prosecute the Nazis. What is the Nazis' defense? It's a purely positivistic defense. Whose law are you trying us under? Our law permitted us to do what we did. Your law didn't apply to us. And Jackson has to appeal to a deeper conception. He doesn't use the word natural law, but he sure seems to be talking about it. It's something that we all understand intuitively. It's a function of human conscience. To say that these men did not violate some deeper law, as if to say no war was fought, no one was killed. It's a powerful closing argument that Jackson gave, at the Nuremberg trials, and our law students should be reading that as well. It's an appeal to natural law.
Yeah, no, it's interesting. So, we're thinking about the beginning of our conversation with Justice Kennedy on freedom. I assume if you took most of your first-year law students and tried to have a deep conversation in class about what is freedom and how should the law respect and sustain freedom, it seems right now they would probably give an answer somewhere around what Justice Kennedy said.
Yeah, they would. But what I find is, underlying that confusion, is another confusion or ambivalence. Let me put it that way, more neutrally. They sense that there have to be objective moral truths in some sense. In fact, there have to be objective moral truths even for us to make sense of human rights in any sense. Unless a human right is simply, we human beings got together and agreed about it, and so now we're calling it a right. But that isn't what most people mean by the word right. And certainly, if that's all we mean by the word right, it's not going to last any longer than the agreement itself.
Yeah.
So they sense that there must be some, and I like to tease them with, many of them are, interestingly, most of my students are cultural relativists. What is good, what is bad is just a function of what a society or a majority of a society happen to think at a particular time. And I said, well, one of the things I sort of challenged them with is, doesn't that mean that the reformer is always, the Gandhis and the Martin Luther Kings are always by definition wrong, according to your own standard of what it means to be right and wrong? And that stops them. Because I think we all have this sense that there is a real moral progress that can be made, and often, and it has been made in some ways in our era. But moral progress means that there has to be a standard independently of what's happening on the ground. That when one thing changes to another thing, it's not just another thing; it's objectively better by some other standard. And that's the real deeper issue with which I think students have to be confronted, and with which I find many of them struggling, and that's the way to get them to think about natural law.
It's interesting hearing you say that. I think, it seems, and not just students, but just more broadly speaking, I think there's an inchoate sense that there is no foundation for rights. You would think about not a famous conversation, but interesting conversation on CNN. Cuomo, broadcaster Cuomo, I think he's like a nephew or somewhere in the Cuomo family, and he was talking to the Alabama jurist Roy Moore, and debating what is the foundation of our Bill of Rights. And Roy Moore says, rather clumsily, there's a divine, godly foundation to the rights of the Bill of Rights. And Cuomo says, no, these are negotiated. That's that's how we got the Bill of Rights. And the question is, well, if they are negotiated, they're not very stable. The thinking, though, it seems to me, is there's a sense that there is no foundation, and particularly in sort of modern, international human rights talk. I think this is why there's the move to group rights, and there's the move to have everything have a law and a standard and a coercion behind it, precisely because we sense there is no basis in tradition or reason or history for this, and it's a purely subjective thing, and therefore it makes it all the more necessary to have it recognized in law. I mean, in particular, if you think about this sort of, I think it's in the last 2 years, to my mind, this sort of explosion of transgender thinking. It seems to me, precisely because we're saying sexuality is just subjective, with no interaction with the human body, it makes it all the more necessary that everybody recognize my gender identity in law.
I think you've just made the profoundest point of all. I mean, that all of this legal coercion. I mean, I wish more libertarians would see this. That so much of the expansion of law, lowercase, and all the coercion that we see, is a function of our relativism. Is a function of the fact that we intuitively seem to understand that this has to be enforced in a coercive way, because that's the only way people are going to take it seriously. There's nothing deeper.
There's nothing deeper. Question too. I mean, you think about the fall off of the natural law or natural law thinking. It's interesting. I mean, just historically, North American colonial lawyers at the beginning, when as the dispute with the British Empire heats up, in that period after the end of the French and Indian War, and there's this desire to collect debts. And we sort of get this back and forth about the jurisdictional legal status of the colonies within the British Empire. There's this appeal by several American lawyers or colonial lawyers to natural law, and thinking about the foundations of jurisdiction within the empire, and what they're owed and what they're not, what they owe and what they don't owe to the center. Right. And the response of many of the British lawyers is this force. Positivistic thinking, and I've always think to me there's a germ there. There's something there that could be appealed to show just how central natural law thinking is in the American tradition. How these things were just sort of assumed, within our American mind, and could be appealed to. Hadley Arkey's, you may be familiar as sort of his project with early 18th, 19th century jurisprudence, where he says natural law thinking is just shot through Supreme Court opinions.
Yeah. I think it really begins to fade. I'm sure you're familiar with Edwin Corwin's book on liberty. I mean, same thing. It's the creeping utilitarianism by about the beginning of the 19th century, where we see these natural law ideas sort of fade out. But that was the successor, And of course, look at what happened in the beginning. Classical liberals who were utilitarians, people like Bentham, began by thinking the way natural lawyers thought about limited government and things that all classical liberals and libertarians would agree with. But within about 30 years, in fact, even by the end of Bentham's life, he's beginning to sound more and more like an absolutist. And I think that's the tenor of utilitarianism. It's always to try to want to maximize, and who's going to maximize utility? Well, it ought to be the government. So it's very difficult for government not to do that when you begin thinking in those terms.
As you see things now playing out, I mean, it's in constitutional law in particular. I mean, it seems to me I think we're probably going to struggle to hold on to a lot of the negative rights we thought were sort of really baked in to our Constitution. I mean, I think we've talked about religious freedom, freedom of association, but freedom of association has a more problematic constitutional protections, it seems. But then also, I think free speech starts to erode now as we more and more take on these sort of purely subjective criteria. Hurt, informing. And so I'm curious to get your thoughts on that, on where you think sort of now, formally, it seems to me moving away. I don't even know if it's, because I think natural law has just been dismissed, but it seems to me, but it is the case, a libertarian account of a lot of negative rights did sustain itself in the 20th century in our country. It seems to me, longer term thinking, that's less tenuous, or more, less sure.
All we have left once natural law thinking goes is the tradition, and the tradition is now going. So I'm not optimistic. I share the assumption of the question. I think that with the negative rights traditions clearly boiling away, and under the strain of all of these really modern ideas, more modern conceptions. I think that, well, I don't think there's much of constitutional law left. And I remember when I took my constitutional law class at Georgetown, I had a professor who was a Marxist, and somebody asked him about it was a narrow decision, San Antonio School District versus Rodriguez. The court decided there was no constitutional right to an education.
Yeah, I remember.
And you remember that case?
Oh, yeah.
And somebody asked Mark Tushnet, our professor, well, how would you have decided that case? And he said, I decide that case the way I decide every case. I pick the response that's most consistent with the Communist Manifesto. And I remember I was a very naive law student who was assuming I was really taking a constitutional law class, and I almost fell out of my chair because I thought, well, why are we here then? I suppose that's kind of a parochial, anecdotal, naive sort of response to have, but I think many of my classmates did. And then by the end of the year, people were so inured to the fact that they were just making it up as they went along. And I think that's how most lawyers see constitutional law now, is that, we have to put quotes around the idea, around the word law and constitutional law.
It's interesting, too. Another side of the question, Robert Nisbet would argue, maybe not in the natural law vein so much, but others. So if we're in this sort of reign of to think about Justice Kennedy in the mystery passage, the unencumbered self, and so this, in Kennedy's mind, this should lead to a sea of liberty, or ocean of liberty, and we're all sort of freely interacting with one another. A more darker view is it leads to collectivism. Individualism begets collectivism, and that's a Tocquevillian idea.
It absolutely does.
It's interesting to think about. So you said Tushnet. Tushnet wrote a blog post on balkanization maybe a month or two back, basically arguing that these and it was funny. It's a case like the one you mentioned where no, we can actually start to find a constitutional right to education in the due process clause, or not due process clause, equal protection clause. And it's interesting just thinking of how this all could play out.
Right.
Yeah.
Yeah, there's always that's the strangeness of all this. On one foot, the one foot we hop, we're assuming that there's really something objective found there. We can really find a right to education in the Equal Protection Clause, and on the other foot, of course, there's nothing there. There's no text in this room, and it's just it's. I wonder how some of these thinkers really sort of, in their heart of hearts, do they really mean find as if we're discovering something? Or why not just candidly say, we can make an argument that, in some hermeneutic way links up to some of the values that we take to be central to the Equal Protection Clause. But let's dispense with all this sort of finding and discovering, and but once they do that, of course, people see that the jig is up, and you can make your argument and I can make mine, and it's just a matter of who has, as Justice Brennan would say, the 5 votes. Yeah.
Well, John, this has been a great discussion. We've been talking with John Lawrence Hill about his new book, After the Natural Law. Thank you so much for your time today.
Thank you for having me. It's been a pleasure.
This is your host, Richard Greinch, and you have been listening to a podcast that can be found at libertylawsite.org, where you can subscribe, comment, and find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org.